Our topic is the basic principles for persuading Generation X and the Millennials. This simple chart shows us the reasons why we have to be so concerned with this topic. The boomers, 80 million of them, have been our juror pool for years. But now Generation X, which is only 40 million, is still occupying a substantial portion of our jury pool. But the Millennials are 75 million members of our jury pool. Most of the boomers by now, 80 million of them, they're old enough and experienced enough to know how to get out of jury service. So basically we're dealing with Generation X and the Millennials, and it's extremely important to know how to communicate with them because it's very different from communicating with the boomers, and a lot of the things that we've learned early in our practices no longer apply to this brand new generation of millennials. So let's talk about basic principles, first of all, of communications. We remember that in delivery of the message, our verbal communication is only 8% of the delivery of the message. It's not to say verbal communication is not important, because it's very important. The words that we choose to use in the construction of our message, the words that we deliver in our message are very, very important. And we're going to talk later about how we choose our words and how different words work for different generations. But words are only 8% of the delivery of the message. Vocal communication is 37% of the delivery of the message. Vocal communication is the sound, quality, tone, timbre of the voice. It's the use of the pause. It's the ability to use your voice as an instrument and, if you will, as a weapon in gathering, gaining, holding attention of the jury. And one of the major things that makes the vocal part 37% of the delivery of the message is that to a large extent the vocal carries our sincerity. You have to sound as if you believe the message you're delivering. If you don't believe the message, if you don't believe in your client's case, then I respectfully suggest that you get out of the way and let somebody try the case who does believe in it. Because 12 jurors, 12 of our fine citizens off the streets, will pick up through vocal and through nonverbal, particularly, communication as being insincere. And if you're insincere, you're dead in the water, and so is your client's case. But now let's look at a very important thing. This is especially true when it comes to dealing with millennials, and that is that 55% of the message delivery, the communication, is nonverbal communication. So it's important now, what we've learned about communication methods is that we maintain synthesis and consistency between those three categories: vocal, verbal, and nonverbal communication. In other words, your verbal communication, your nonverbal communication, and your vocal communication all have to be delivering the same message in the same way. If there's inconsistency in your message, if there's no synthesis, then the nonverbal communication will prevail. For example, if you are delivering the message to the jury that this is my good friend John that I have the privilege of representing, and then all through your voir dire and through opening, especially voir dire, when you're introducing John to the jury, you're talking about your friend John and what a privilege you are to represent John and tell John's story. But then during the break, all through the trial, John's sitting there by himself during the breaks, he's sitting by himself at lunch, and you're ignoring John completely. Your nonverbal communication is sending the message to the jury that John is not really your friend. John is just what they believe anyway, if they're tort reformers. He's just an instrument for you to make money. You're just another greedy trial lawyer who's in there trying to sell them a bill of goods. So that's an easy message for them to receive because they're preconditioned to receive it. If you say that this is my client whom I'm privileged to represent, you have to say it, you have to mean it, and you have to convey it vocally, verbally, and non-verbally, because what happens is this. If you are delivering an inconsistent message, and you're saying one thing and you're delivering a vocal and nonverbal message, the same message in different way, and it's inconsistent, the nonverbal will prevail. So if the nonverbal prevails, that means that the verbal communication is being rejected. In other words, your message is being rejected by them as insincere or as just untruthful and untrustworthy. So that can be absolutely devastating to you and to your client's claim, because trustworthiness is what this is all about. We have to maintain our trustworthiness with the jury if we're going to be successful in delivering our client's message. In data processing, we all process information in three ways. We process information auditorily, the sound. We process information visually, with sight. And we process information kinesthetically. Kinesthetic processing of the message is it's that gut feeling. This is when the jury goes into the jury room and the foreman of the jury says, you know, I heard the lawyer's message and he presented it very well, but something about that plaintiff's case just doesn't feel right to me. Well, that's something that doesn't feel right as often as not. They can't quite put their finger on it. As often as not, that's a kinesthetic sensation that arises out of what they have seen non-verbally. They know what they heard, they know how they heard it, but they just didn't quite buy it. That's because they were seeing nonverbal communication that was inconsistent with it. And the kinesthetic feel that they got from it, the gut level feel was that this is an untruthful message. When you do that, it just tears at your trustworthiness. To tell you how important it is for jurors to trust lawyers, there was a big survey done on part of a much larger debriefing of actual jurors in a 1,500 question survey. And one of the questions was whether they liked the lawyer and why they liked the lawyer, if they did. And what came out of that was there are three things that make jurors like lawyers. Number one is dynamism. Dynamism is just merely keeping them awake, keeping them interested, keeping them engaged, keeping them involved, and being interactive with them, making them feel like that they're not just a spectator, they're not sitting in a movie theater watching all this unfold on a screen, they're actually actively involved in it. They have to use their own brains to do more than just listen to what you're saying. They have to engage, they have to calculate, they have to make their own decisions about things based upon what you're presenting to them in an interactive fashion, so that they feel that the decision that they're making is theirs. They feel that the story of the case that they're developing is theirs, because there are going to be three stories in the case. There's going to be the plaintiff's story, there's going to be the defendant's story, and then there's going to be each individual juror's story, their understanding, their belief about what this case is about. The plaintiff's story is the one you're conveying. The defense story is the one, obviously, that is being used as an alternate choice, or first of all, to tear down the plaintiff's story, but secondly, to present their own story about what happened. The juror's story is the story that when they go home at night and the spouse says, what happened in court today? They say, well, this case is all about, and what they say after that is their current version of the story, what this case is about. So the idea is that if you can get them engaged interactively so that your story becomes their story, that's how you lead to a just result for your client in a case, and you do that through dynamic presentation. Dynamism is the opposite of boredom. Boredom is what they most frequently get. Boring is the most frequently used word to describe jury service. The second thing is efficiency. They don't want their time wasted. Now, this applies as much to judges as it does to juries, obviously. They really resent it when you come in and waste their time. They don't like unnecessary objections that just seem to be for the purpose of harassing the other side, or they don't like unnecessary objections that just seem to waste their time and the court's time when everybody in the courtroom knows what's going on. So you want to be efficient. Efficiency, you need to have your predicates ready. Know what your predicates are. Don't be stumbling around trying to remember what a predicate for a piece of evidence is. Do things efficiently. And you want to create an anchor. And the anchor is this, that when the judge calls your name, when the judge says, in my case, all right, Mr. Nations, you may proceed. When they hear my name, I want them to have an anchor that is, okay, something is about to happen that I need to listen to. That needs to be the anchor you create with your efficiency. And the way you create that anchor is that when your name is called, make something happen. Do something. Do something that engages the jury. Have something to offer. And it doesn't happen when you just say, now, let me understand. Did you just tell the jury this, and this? Yeah, that's what I told the jury. Well, that's what the jury just heard too. Be efficient. Be professional. And be interactive with the jury by everything you do should be enhancing your story or tearing down the story of the other side and conveying the very strong message to the jury that your story should be their story. The next thing is trustworthiness, which I've talked about 3 times now, because liking lawyers, predicated on dynamism and efficiency, I think is most strongly predicated on trustworthiness. Because I think if you lose trustworthiness, you've basically lost the case. If they don't buy your story is the client's case. If they don't buy your story, they don't buy your client's case. I've seen cases won by lawyers who were not dynamic, who were not keeping the jury awake particularly because maybe their opponent is putting them to sleep even worse. I've seen cases won by lawyers who stumble through and are not so efficient. But it's hard to imagine a case being won by a lawyer who is just totally untrustworthy, who's lost the trustworthiness of the jury, unless their client just has complete trustworthiness and they have a strong case that the jury just simply wants to bring in a verdict for that particular client of that particular lawyer. So dynamism, efficiency, and trustworthiness. Now let's talk about Generation X and Generation Y. First of all, they're generational designations. The GI generation, as exemplified by Reagan and by Mae West, born between 1901 and 1924. They were called the GI generation. The silent generation, why they call MLK and Sandra O'Connor and that generation silent, I'll never know. They didn't seem very silent to me. But they were born between 25 and 42. The boomer generation is 43 to 60, and those are exemplified by the Clintons. The Generation X, born from 61 to 81, Kobe Bryant is an example of that, and I'll give you other examples. Gen Y, Mila Kunis, born 82 to 2002. Now let's talk about the Gen X from 61 to 81. Examples of that generation are Michael Jackson, Kobe Bryant, Leonardo DiCaprio, Serena Williams. There are 40 million members of that generation, half the number of the previous generation, the boomer generation. But they were still important to us, and we're going to see why. They're still very important to us. These are your typical tort reformer generation members. The Generation Y, which are also called the Millennials, they prefer to be known as the Millennials, born between 82 and 2002. Mila Kunis, Zach Hansen, the Olsen twins, 75 million of them are now in our jury pool. Now, the next generation is probably going to be known as Generation W. I've heard Generation Z, but W is for the World Wide Web, and that seems to be what's going to come down the pike. But let's talk about what designates generations. There are generational cohorts that tie people together within their generation, and there are core values. And core values is all about decision making. So the core values of a generation is something we really need to understand, because those are cohorts that tie generational members together. But the core values are the events that occur at various critical points in the group's lifetime that create cohorts and define their core values. Events that define core values. So the sociological events that occur at economic adulthood create a lifelong attitude towards jobs, money, and savings. Money has a lot to do, their attitude about money has a lot to do with what they're willing to award in terms of a jury award, in terms of damages. So that's the sociological events at economic adulthood, so we'll look at that. These core values, the core values, are carried through life largely unchanged. You can change beliefs, you can change reasoning at the moment, but we don't change core value. We have to learn how to appeal to core value because their decisions are made within the context of their core values. Their beliefs may change. Their core values are much less likely to change. So we really need to understand what their core values are and what the things are that have influenced the development of their core values. Generational predispositions exist. They are predisposed to do things. When these cohorts are understood by lawyers and utilized by knowledgeable attorneys, we can take advantage of that knowledge to know how to couch our submissions to a jury in a way that it will reach and resonate with their core values, keeping in mind that the core values are different between Boomers, Generation X, and Generation Y. And of course, we have a mixture of all three in our juries. So we have to create a message that appeals to all of these generations. But the main thing about this is if you learn what those are, you can make sure you don't leave one out, leave out a group. Now, caveat emptor. These are not hasty generalizations or generational anecdotes. When I first started practicing, we were given a lot of generational anecdotes. There were no forensic psychologists back when I started practicing. We were mostly told generational anecdotes by the people who preceded us in this business, and they would use very strong, hasty generalizations. They would say, for example, that German juries are very strong punishing. So be careful about taking a criminal case in front of a German jury if you can avoid it, because they're very punishing. On the other hand, if you're looking for a large exemplary damages verdict, you might want to have that same German jury. You want to hear a silly one that they taught us early was that you don't want women on a jury if you're looking for large damages, because women make the decisions with respect to buying groceries and things of that nature, so they think in terms of pennies and dollars, whereas men make the large decisions about buying a home and spending big money. So men are predisposed to big money while women are predisposed to spending small sums of money. I don't know where those women were, but they certainly weren't in my generation. Current data. This is not based upon, what I'm telling you today is not based upon the hasty generalizations. This is based upon generational studies by sociologists. And it's also based on a lot of demographic research. A lot of study has gone into these folks. And of course, what are they studying? They're studying them for economic reasons. They're studying these generations so that they will know what appeals to them in advertising, what appeals to them in terms of how do you get into their pocket, how do you get them to spend money, how do you get them to buy your product as opposed to a different type of product, what kind of appeal do you make to each of these generations. They understand that there's very, very, very big money. There are billions and billions and billions of dollars involved in those decisions, in understanding how do you appeal, how do you reach Generation X, how do you reach Generation Y. And most of the television that you see on commercial television today, on your standard networks, and most of the programming is very definitely keyed towards the younger generations. This is why now we have Jimmy Kimmel, and we have the younger, starting with Jimmy Kimmel, now we have the younger host of the evening shows. And we're soon going to have Stephen Colbert replacing David Letterman. You've got demographic outreach because they're trying to figure out what these people want. So this is based upon strong demographic research. We're taking that, and it's taken by forensic psychologists who then apply this to how does this data work with respect to what we're doing with juries when you get those folks in the jury box. Let's talk about Generation X. They were born from 61 to 81. Their current ages are 33 to 53. And they're called X, and boy, they really resent this, but they're called X because of their lack of generational cohorts. They didn't have those big events that tied them together, the way obviously World War II tied together the boomer, that generation, what they now call the greatest generation. We've had 9/11, the assassination of Kennedy, that sort of thing. Those are things that give strong self-identification to generations. Generation X was said not to have such generational cohorts. The generational values that affect core values, likes and dislikes, are the very important things that we have to look at with respect to Generation X. First of all, divorce rates. They had the highest divorce rates of any generation so far. The reason divorce rates are so important is because when you're engaged in divorce, that's just about the worst impression you ever get of the legal system, of the justice system. Few people ever walk out of a divorce court after a long bloody battle in divorce and say, well, I got justice. So it's a very bad impression of the entire judicial system. Not only your generation getting more divorces, but you see your parents getting divorced. When you're the children of divorce, you have the same types of problems, of a bad impression of the judicial system. Generation X had more children out of wedlock than any generation in history. They had an increased number of absent fathers, and that started tearing at the core values, the family unit, which is often very important. Maintaining the family unit, or the value of the family unit, is often very important in our proof, in wrongful death cases of a family member, things of that nature. The Generation X, their social phenomena is aside from the divorce rate, but they ended up with disrespect for divorce laws. But then they had something that was much more important to them. They were the first generation that had a dwindling education. The generation before them, the boomers, had the advantage of the GI Bill. So they had a huge influx into the colleges from the boomer generation, because they had the GI Bill and they had a lot of educational opportunities. Plus, there were less of them than there are Generation X. Gen X has the high crime rate, the highest crime rate. It was just increasing all over the country. The characteristics of stability. What they seek coming out of all this mess that they were raised in is they seek balance and perspective. And they put emphasis on leisure and entertainment because they saw their parents working and they saw a lot of broken families, and they saw the breakup of the basic family unit in a lot of homes, and so they're now looking for leisure and entertainment. They were the first generation that went back in and had a home office, the idea of a home office. Previous generations didn't have an office at home. A lot of these people did have a home office, and a lot of it was because of the employment situation that they faced. They had to work at home. Stability. They were the first generation that started staying home longer, and they were closer to their parents, and they postponed independent living. And so that has an effect now, that if you're talking about Generation X, you have to remember that if you're trying a death case involving the death of a parent, that Generation X, 51% admire their parents the most, and they take responsibility for their aging parents more than previous generations ever did. And one of the reasons they admire their parents most is because they came back home and spent more time with them. They stayed with them longer. A lot of them average up to age 28 at home, whereas previous generations, they were leaving home at 18, 19, 20, and staying away, starting their own lives. But Gen X came back home after college even. And so they have a much closer relationship with their parents, which is very important when you start talking about evidence of the proof that as a result of a tragedy that occurred, the family unit has been broken up. And the parents, a loss of a parent or the loss of a child, is very important. The self-reliance, now this is a very big theme, and you're going to think about this as you go through this, because this is the generation that Karl Rove and others decided were the perfect targets for tort reform. And they were absolutely right. These people were the targets of tort reform because they were preconditioned, because of these generational cohorts and so forth, they were preconditioned to believe in the rhetoric of tort reform, starting with self-reliance. They were in the situation, unlike previous generations, where both parents were working outside the home. The basic family unit of dad going off to work, the TV family, dad going off to work, mom staying home, taking care of the kids, having dinner on the table at night, everybody sitting down to the dinner table together at night, having breakfast together in the morning, church together on Sunday. That went away, beginning with Generation X in a big way. Both parents were working outside the home. This generation grew up extremely independent, and as a result, they became very self-reliant. Another big impact on them were the Reagan social cuts. When Reagan took office, did away with all the social assistance from the federal government, essentially, they were left with the opinion that, okay, I've got to take care of myself because nobody's going to take care of me. And so here comes the biggest theme in the courtroom today. It grew out of this generation. Personal responsibility. I think personal responsibility is the biggest single theme in the courtroom today in personal injury litigation. Everybody wants to wrap their arms around personal responsibility. As a plaintiff's attorney, you need to make personal responsibility your theme, and boy, especially with Generation X, because these people invented personal responsibility. And Rove and the other forces of evil understood how susceptible this generation would be in tort reform to the concept of self-reliance and the concept of personal responsibility. So they made personal responsibility the central theme, except they adopted it for the defense. They made personal responsibility the theme in this fashion, that why are you coming to asking me as a juror to take care of you? You should be taking care of yourself. I took care of myself because my parents were outside the home. We had cuts. I couldn't get a job. I had to work out of a home office that doing a sales job or whatever. I didn't have those opportunities. Why aren't you taking care of yourself? I'm personally responsible, so should you be. All right, that was the heart of tort reform and remains so today. But you have to turn this around. You have to turn this around on voir dire examination and very early in the trial. You have to make, with the opportunity to speak first on behalf of the plaintiff, we have to make personal responsibility our theme. And you do that by telling people on voir dire examination that Mr. Jones, the plaintiff in this case, ask that you carefully examine his conduct in this case. And he takes personal responsibility for all of his own actions in this case. And the reason we're here today is because this defendant refuses to take personal responsibility for their actions, for their decision to drive in excess of the speed limit, to break the rule regarding travel, speed in this country. And they will not take responsibility for this. We're going to call upon you to place personal responsibility on this defendant by returning a jury or whatever. Okay, but the whole idea is you take personal responsibility, right? Take it off the bat so before they get a chance to do it. Now, Gen X was of the opinion that they could not rely on the government. They went through 8 years of Reagan, 4 years of Bush, with little or no help from the federal government. They had to take care of their own health care, a very important issue today and then and since then. They had to take care of their own health care. Think about how that resonates with them. When you're asking them to provide money for your client's health care, for future health care, for what's been done to them in the past, they're saying, wait a minute, I provide for my own health care, why don't you? Self-reliance. They have no deference to authority. The breakdown in authority began with the high divorce rate, with bad attitudes about the court. And then it really came about as a result of, as much as anything else, tort reform, by being pounded constantly by tort reformers and being told that you can't rely on the judicial system, you can't believe in judges, you can't believe in jurors, nobody is going to be doing anything for you. You have to do things for yourself. You're totally personally responsible for your own life. And so they end up with absolutely no deference to authority. In the employment situation, this generation had no job security, none. They had no confidence that they could keep a job if they got one. Their job security was completely up for grabs. There were attacks made. This is when there were very, very strong attacks made as part of tort reform. Tort reform was an attack on the trial lawyers, on the judicial system, but it was also an attack on the unions. And so as the unions' power diminished, so did job security for people who would have ordinarily been union members. So this generation had less job security. They were the first declining wage generation. And again, part of that is because of the success of tort reform in fighting the unions and in fighting the judicial system. But they had declining wages. So if you're going to go in and try to prove to a Generation X member that your client has a problem because they can't get a job, or because since they were injured, they have no job security now. They can't depend on keeping the job they have because they're injured, or because they're injured, they're not making as much money now as they made before. They say, welcome to my world. And so you really have to keep this in mind when you're picking juries, that you're not going to get nearly as much empathy from Generation X on a big wage loss case, a big economic damage case as a result of a personal injury, as you might from a different generation. Politics, they're the post-Nixon attitude towards politics. This is when they basically disengaged. They had a weak attachment to political parties. They watched all the television of the whole Nixon hearings, and then they saw all the things that followed that. Politicians went to jail, and they just weren't interested in it. Plus, that combined with the fact that politicians weren't doing anything for them anyway, with all the Reagan cuts. So they detached from political parties. They have the lowest, today still, generally they have the lowest voter participation, and they have no belief in politicians. The X factor, what are the characteristics of Generation X? Well, the X factor is the fact that they didn't have a common enemy. They had no clear idea of who they are. They have no clear rallying points, and they have no clear national principles, because they had no clear national leadership that were creating and applying principles that would apply to them. It was hard to discern clear national principles when they grew up in that whole morass of Nixon and the whole infighting in Washington. Now, if you remember, this is a generational thing. If you go back and pick some individual people from Generation X and what Generation X produced for this country, individually, phenomenal. There's been huge success emanating directly from Generation X members. But these are general propositions, general characteristics of the generation as a whole. They certainly do not apply to every member of that generation, but they're just attitudes. The core values are different here than they are from other generations. Time magazine, you call us slackers, dismissed us as Generation X, and they were very obviously upset by it, and with good reason. Now, under diversity, they became more tolerant of people who were not exactly like them. They're more ethnically diverse, and they had more ethnic acceptance. And the thing that carries that forward that's very, very important in this country on ethnic acceptance has been music. The way music crosses across every generation and appeals across generational lines, and it appeals across ethnic lines, and it appeals across all kinds of lines. So there was more diversity in Generation X, more tolerant. And then Generation X women, you'll remember, they placed greater importance on the home and the family that they missed. Remember, they're from the broken home. They're from the highest divorce rate. They're from the two parents working outside the home. So they put far greater importance. This is not going to happen to us. They put greater importance on their home and on their families. So Gen X women could be a very good choice from a characteristic viewpoint, generational characteristic viewpoint. If you have a case in which the family has been destroyed, or the family has been severely damaged by the negligence of the other party, because home and family are important. This generation refused to compromise family and quality of life for a career. They were not the ambitious go-getter, let's break through the glass ceiling. They were more in terms of let's raise a good, solid, educated family so that the next generation will be better than ours and have better income, have better education, have better and greater opportunities at every level. So generational X women are something pretty special that you have to keep in mind when when you're picking a jury. They disavow the association with feminism. This is not the bra burners, but they're the daughters of those boomer feminists. The feminists were the boomers, but they claim the benefits that they got from the boomers, but they disavow the associations with them. Now, this is why there's another reason why there's such a really good target for tort reform. They ended up with a conservative mentality. They're very cautious and practical. And they had so much hype and insincerity. They saw so much insincerity coming out of the politicians, I think, more than anything else in their generation. So they reject hype and insincerity. They reject overstatement and flash. Keep this in mind when you're thinking about your demonstrative evidence, when you're thinking about your closing arguments, when you're thinking about hyperbole. When you stand up and talk in terms of the hyperbolic general statements, that overstatement is rejected by this conservative mentality, as it should be. I mean, overstatement and flash should be rejected by everybody, but these people are very, very much opposed. They're very attuned to it, the Generation X. They resist conspicuous consumption. They're more conservative than the boomers, this is where they were really tapped into. This generation was heavily tapped into by Reagan. He cut them off from the benefits of the federal government, but a lot of these folks followed Reagan, and so they ended up they got caught up in the Republican conservative movement. They're skeptical towards blind liberalism. The boomers were the idealistic blind liberals, and now this is very important for us. If you're trying a case against corporations, which we often do, the boomers were skeptical about corporate America. They were skeptical about the influence of corporate America, the military-industrial complex that Eisenhower warned us of. And we could stand up in front of a boomer jury, and we did many occasions, and begin a 4 hour by saying this is just another typical case in which a greedy corporation has placed profits ahead of the safety of the American public. You're gonna get a bad result if you try to do that today. You wouldn't get the right response that you want if you try to do it to this conservative Generation X group. Number one, because they've been just fed tort reform for their entire lives. But number two, they reject just the straight up anti-corporate mentality. They don't buy into it at all. So you can prove that this corporation is bad and what this corporation did on this occasion is bad. You don't have to take on any more burden of proof, and don't take on any more burden of proof than you have to have. We don't have to prove that the entire corporate world is just greedy and designing bad products for their own profit. We don't have to prove that this corporation is doing that across the board in everything we do. All we have to prove is that this corporation on this occasion on this product, in this particular design of this particular part, this defective part, in this occasion, they made a mistake, they covered it up, whatever your evidence is, and as a result of that, they injured our client. So don't take on any greater burden of proof than you have to carry, and you take that on when you start talking hyperbolically about anti-corporate America themes, and right off the bat, you're going to raise the skepticism of these juries. So those days are gone. These folks were the perfect target for tort reformers, as I've said many times, because they ended up with this anti-corporate mentality, or they rejected the anti-corporate mentality. How do you communicate with them? They're raised as tort reformers. They were raised with personal responsibility as their own theme, so it's the theme that they resonate to. So as I've said, adopt this. Be sure you get personal responsibility as the plaintiff's theme going in. They are the generation that were first taught about how everything we file is a frivolous lawsuit, and how the frivolous lawsuits are clogging the courts, and how you can't get a real case to trial because the frivolous lawsuits are clogging the courts in front of the legitimate cases. And the reason it takes 3 to 4 years to get a case to trial is because of frivolous lawsuits. One of the things I've done successfully with Gen X on this frivolous lawsuit issue is I say, okay, you've heard about frivolous lawsuits, but sir, you pick one out. Sir, you talk about frivolous lawsuits. But let me ask you this. How do you feel about frivolous defenses? Suppose you had a defense in a case, and you take one where they've just had one of those pleadings that sets out every possible defense they can think of. And I've taken this out of it. I say, I'm looking at the pleading that they filed in this case. They've said at the defense that this was an act of God. Now, sir, are you willing to listen along carefully to the evidence in this case and listen carefully to see if there's an act of God involved here? And if there's not, how would you feel about that as a frivolous defense? And that's gotten some really good, it gets some good results on voir dire examination, but it gets a good discussion started too. So you shift the discussion. Frivolous malpractice cases. They seriously believe, the medical society has done a great job in making them believe that all malpractice cases are frivolous. They've ended up with tort reform all over the country, and especially in Texas, that just protects medical malpractice. It protects the practitioners of medical malpractice. And the result is that medical errors are now one of the greatest causes of death in this country. And the numbers are increasing exponentially. But they've been successful with it. And they've been successful with it. And remember this, it was this generation they sold it to. So think about that when you're looking at Gen X jurors. They think greedy trial lawyers is one word. They've been hearing this their entire life. They were raised with greedy trial lawyers. So what you can do about that is make very certain that you're not playing into their preconceived notion of what a greedy trial lawyer is. So when you stand up, you've got a couple of strikes against you, and if you want to get that third strike very quickly, then stand up on voir dire and start using the rhetoric that they would expect from a greedy trial lawyer. Start using hyperbole. Start making a lot of promises that you know you can't possibly keep. Start making attacks on the defendant that you know you can't possibly prove. Go ahead and just play right into that, and then see the consequences of it. It's just stupid. They have Gen X has a conservative skepticism. They're skeptical of us, but more importantly, they also reject the boomer rhetoric regarding, when we had the boomers on the stand, they always cheer for the underdog. That was a characteristic of their generation. They'd pull for the underdog, which is great for us because generally we represent the underdog. Generation X doesn't buy into the rhetoric regarding cheering for the underdog. That's important to us. They don't buy into the rhetoric regarding evil corporate America, because evil corporate America has trained them that it's really the trial lawyers that are evil, picking on poor old corporate America. They believe that the equality for all is just too idealistic, that there is no such thing. And a lot of the opinions of the United States Supreme Court have led to that. There's not equality for all. They see a lot of bad results in the criminal courts, making people understand that there's not equality for all. They are also very conservative. They have one of the things that they did have during their generation was the AIDS crisis. age crisis tended to create a very conservative and cautious mentality among Gen Xers. They're very value-oriented in products. So we have to keep that in mind. They go to a lot of trouble to figure out what's the true value of something that they're buying, as opposed to it goes right along with rejecting hyperbole and flash. They try to work their way, since they're conservative, they try to work their way through the flash and get down to the actual value. Okay, this carries right over to our evidence. They try to work through the flash, they try to work through the hyperbole, and arrive at a real value. And so when we're proving up a case to Generation X jurors, we have to prove the numbers that we give them. You can't just stand up and say that a reasonable award for physical pain and mental anguish in this case is $500,000. They want to know why it's $500,000. They want to know, how did you arrive at that? Why is it $500,000 instead of $400,000? Why is it $500,000 instead of $438,000? Where do you get that number? You can't just, they're very value oriented, so you have to be able to show them how you arrive at the figures you've arrived at. It's extremely important. They're very cautious with money. So they may very well be cautious with the defendant's money. They'll be more cautious with the defendant's money than the boomers were. So show them why. Give them a good reason why this case is worth this amount of money. They learn best, like every generation, they learn best through imagery. They were the ones that they're not seduced by flashy advertising, but they reject flashiness. But there's a difference in imagery between just being flashy and presenting persuasive, interactive imagery that they can relate to, imagery that tells a story or adds to the story that we're telling. And I'll talk to you about that when we talk about demonstrative evidence. Cynicism. You gotta love this one. They believe more in UFOs than in their receipt of Social Security. So this is a lot of the members of this generation are members of the right wing, the far right wing, and members of the Republican Party base. I was amazed by this statistic, though, that only 25% regard themselves as religious. Now, when you look at that on the surface, that only 25% regard themselves as religious, it doesn't make a lot of sense. But a lot of people, they rejected a lot of the flashiness and a lot of the overstatement. And this is the generation that, to a large extent, came up with the TV evangelist. And there were all kind of scandals with TV evangelists. And I think they were flashy, and they dealt in hyperbole. And I think a lot of that had to do with the rejection of religion. It's not to say that they're not religious, because they are. But I think what they're rejecting is organized religion. They're rejecting the church, as opposed to, that is not to say that they don't have a belief in a supreme being, but it is to say that they reject the organized church and a lot of hyperbole that comes out of the organized church. These folks were visually educated. They were the first generation that were computer literate. In fact, they're the generation that created a lot of the computer science that provided all this for the rest of us. They're more moved by images than words. Let me say that again. They are more moved by images than words. So nonverbal communication, 55% of the persuasive process. So words, 8% of the persuasive process. That applies to everybody. They're more moved by images than words. These people were visually educated. they learn best through the use of multimedia. And so we always try to make a very strong multimedia presentation to the jury without getting into flashiness, without getting into hyperbole. Make an honest presentation in the fashion of multimedia. Give them a lot of things to look at so that they can interact. They multitask, not like Gen Y, not like the Millennials, but this group multitask. One of the reasons they multitask is because television was their life. They had so much television was really in its heyday, and people started, instead of having dinner at the dining room table, they would sit in the living room and watch television, but they'd be doing something else while they're watching television. So they learned to multitask. The spoken words to them are boring. They have, now this is important too, and it applies to both Gen X and Gen Y. They have high regard for long-established tradition. So if you have a malpractice case, for example, the long-established tradition is the Hippocratic Oath, first do no harm. And I've started many a cross-examination with now doctor, can we agree that you were taught in medical school that first do no harm? The Hippocratic Oath is the creed of your profession, yes. Now let's talk about the harm that you did in this case and then move on to there. So they relate to cases where you can show that the Hippocratic Oath was broken, or that any other rule or any other long-standing tradition was broken. Long-standing traditions is a hallmark of the conservative mentality, so this is not anything unexpected, but it's something we have to keep in mind when dealing with them. They're persuaded by themes that deal with ethics, rules, morality, and so when you're talking about traditions, when you're talking about rules, you're talking about the rules of the road, which is such a popular term today. In medical malpractice, you want to prove the protocols. What are the protocols that control that they're within the profession, established by the profession for the safety of the patient? What specific protocol, medical protocol, was broken here? What specific medical rule of safety for the patient was broken here by this medical care provider that injured this patient? If you're talking about safety rules at a job site or safety rules in design of a product, things of that nature, those rules are critical. And this generation and especially the Millennials resonate to those rules. So you don't just talk about those rules. You show those rules. You put those rules up. You explain the rule. You have an expert explain the rule, or you have anyone explain the rule who's qualified. You explain the rule, you explain the reason, let them look at it, show and tell. Let them look at the rule. Then explain the reason for the rule. What is its purpose? What was it designed to prevent? Who was it designed to protect? And then talk about how the defendant broke the rule, and by breaking the rule, who did it injure, and how did the injury occur? And so you carry that all the way through. You make a big deal out of rules because these people were born and raised with rules. So rules of the road are important. They relate to themes that appeal to pragmatism. They believe in that you hope for the best and plan for the worst. This can backfire on an anti-plaintiff, in an anti-plaintiff hindsight bias if you don't do it right, because the hindsight bias is they will look back when they're reviewing things in the jury room. If they're not guided otherwise, they will look back to the last thing that occurred, and they'll say, well, they should have, and the last thing that occurred was usually an action by the plaintiff before they were injured, their reaction or whatever. But they'll look back and they'll say, well, the plaintiff should have seen this. That is, the plaintiff should have planned for the worst. So what happened here to the plaintiff could have been prevented by the plaintiff if the plaintiff had planned for the worst, if they had foreseen this. And then they use defensive attribution that says, I know I would have foreseen it. I know I would have done this. I would have done that. I would have done something to prevent this. So, but that's their pragmatic approach. Since they are so very self-reliant, they resonate to themes where someone has lost their self-reliance. If you have a plaintiff who has lost his or her ability to rely upon themselves and do for themselves and care for themselves and feed themselves and work for themselves and do all the things for themselves that we do as part of self-reliance, this is your generation. Because when you talk about a plaintiff, you talk in terms of three things, three different views of the plaintiff. Because you always want to think, when you're proving damage, you always want to remember three words. Compared to what? The plaintiff's condition, what is the plaintiff's condition today? Well, it's one thing to prove the plaintiff's condition today, but compared to what? So the first thing you prove is the plaintiff's condition before this tragedy. And you go into great detail proving how self-reliant they were, all the things they could do before, and all the things they did for themselves before. Then you talk about their status today, and all those things that they were self-reliant and could do for themselves that they can no longer do for themselves, that they have to rely upon someone else to do for them. The more serious the injury, the more this just becomes just absolutely devastating proof against the defendant. So then you talk about life care plan and what's going to be the future and their lack of self-reliance in the future. This is not just important, this is a defining Gen X characteristic, because they were the first truly self-reliant generation. They resonate to themes that deal with loss of independence. And because they're so independent themselves. They were forced to be independent. Both parents out of the home, they came home in the afternoon from school and they were there alone. And they had to be independent. And again, this is a Gen X characteristic. So you want to prove loss of independence. Again, it goes back to self-reliance. What are all those things that they can't do now independently that they could do before? But you talk about it in terms of their loss of independence. You talk about if the close relationship between parents and children. They value this, and in the right case where there's damage to the parent-child relationship in any fashion, then this is the generation. They're very strong about it because they place family and the quality of life ahead of a career. More than any other generation, these Xers, you cannot put a plaintiff on the stand to whine about their injuries. You cannot put a plaintiff on the stand to whine about their injuries. We try to put the plaintiff on the stand and ask them a very few questions. We try to prove up the injuries through other people. We don't want to put the plaintiff on and have them just testify to all the things they can't do. We have other people testify to all the things that this person used to do in self-reliance that they can no longer do. We have them talk about what the plaintiff testifies to is that they're doing the best they can with what they have left, that they have a plan for rehabilitation, that they're on a program of rehabilitation, that they're doing therapy, they're doing whatever it is they're doing. Because you want to put the plaintiff on the stand just long enough to project one thing, and all you need is courage. That should be the overriding theme, I believe. I believe a jury resonates to courage in an injured party more than any other single element. That this is a person who's doing the best they can with what they have left, because they will then want to help those who help themselves. So if you put the plaintiff on to prove that they're doing everything they can for themselves, then you got a much better chance that the jury will be willing to help them. But do not put the plaintiff on and have them whine about their own injuries. Exers don't respond to overstatement. They don't respond to hyperbole or dramatic presentation. It's important to support all claims of your injured party substantively. This is what's known as conscious mind evidence. Substantively, in other words, when you prove physical pain and mental anguish, you can talk about physical pain and mental anguish, but you need to offer evidence of physical pain and mental anguish, more than just a plaintiff saying, well, it hurts here. You need to have the medical records that show that it was notated daily by the nurses of the level of pain. You may have the nurses testify the pain that the plaintiff endured. You have the therapist. Therapists are great witnesses as to the pain, the frustration, and the disability that that this plaintiff has, and that's substantive proof. When these people come in who are in the process of trying to heal someone, and they bring in their records and show what was done and what was required and all the things that are going to be needed in the future, that's substantive evidence, and that resonates in the conscious mind. All right, so that's basically Gen X in a nutshell. Now let's talk about Gen Y. Gen Y, this is their hero. Colbert and the Daily Show with Jon Stewart. They get their news not from CBS, NBC, or ABC. They get their news from the Daily Show with Jon Stewart and from the Colbert Report, which is fine because it's actually the most accurate news there is. Generation Y, the Millennials. The problem we have is that how do we get the Millennials to focus on our evidence and to listen to us when they won't even talk to each other or listen to each other? These are people who sit across the table from each other and text each other instead of talking. I was giving this speech to the ABA, about 500 people in the room, and there was a young man on the front row, and I said, okay, do you have a significant other that you can reach by phone right now? He said, yes. I said, okay, would you be so kind as to call her? So he calls, and the phone ring, 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 ring. Nothing. So he hangs up. I said, okay, wait for it. Wait for it. Ding. Text message. I said, okay, don't tell me, let me guess. It says, what's up? And he said, yeah, that's what it says. I said, well, pick up the phone and call her and tell her, or I guess you'll have to text her and tell her that what's up is I want to talk to you on the telephone, which is why I called you on the telephone. They won't talk to each other. They don't listen to each other. So what in the world makes you think they're going to listen to you and me? So let's talk about how we can get the Millennials to focus on our evidence. First of all, we have to achieve focus. We have to understand what motivates this generation. It's all about show and tell. Third grade school teachers could teach us so much as trial lawyers because they understand show and tell very well. But with this generation, and all generations actually, it's mostly show. So we talk about some standard focus techniques as to how you focus your message. Now, the demographics of the Millennials. They're born between 82 and 02. Their ages are, at the moment, are 12 to 32, They're the children of the boomers. They're the siblings of the Xers. Now, the reason they are just completely high-tech. 94% have cell phones, 76% use instant messaging, and 92% multitask and messaging. They're the second largest population. There's 75 million of them. 38% self-identify as white. They're more liberal and more democratic than ever before. And 50% of these folks are entering college, so they will be the most educated generation in our history. They are different. The reason they call themselves millennials is because they graduated from high school in the year the first batch of them graduated from high school in the year 2000. So they tag themselves the millennials as opposed to Generation Y. But look at this. You're talking about a case where you've got a plaintiff who's got the inability to find a job now that he's been injured. Well, you know, it's again, welcome to our world. Their unemployment rate is 20%. They have less health insurance. They have the highest rate of obesity. They have concerns regarding their own declining health. And they feel, here's where they differ completely from Gen X. They feel that the federal government should do more for them, and all governments should do more for them. Gen X is the one that has the signs saying, keep your hands off the federal government, keep the federal government's hands off my Medicare. They have an adverse view of business, which means that they're intelligent. They want a job with self-esteem. They're heavily burdened with school debt. And they're so heavily burdened with school debt, this is where a major part of the resentment comes against politicians and against the banks and against the corporations who bought up their notes and who now hold their school debt. A lot of these folks who graduate from college today have $150,000, $200,000 school debt that they have to deal with, and they're looking at that in the face of a 20% unemployment rate. So they're a burdened generation. They're living, which is one of the reasons why they're living with their parents longer. They have a closer relationship with their parents. They talk to an average of 1.5 times per day on a wide variety of topics with their parents. They accept authority because they're living with their parents longer. They're staying in their household. They're relying on their parents heavily. But these folks were taught to accept authority too because of the way they were raised. The millennials were raised from the time they could walk. They were put into groups. They were put into teams. All their sports are organized, and they're taught from the beginning. They have to listen to the coach. If they don't listen to the coach, they don't get to play. So they're taught to respect authority right off the bat. And they're taught rules right off the bat. They're taught games with rules. Everything is done in organizations. Everything is done in leagues right off the bat, just from their earliest time. And so they have to learn rules. They have to accept authority. They have to. They're accustomed to being supervised, because they're supervised right from the crib on up. And so for this group, things like rules of the road are even more stronger. They're even more influential than with the Generation X people. Rules of the road resonate with them because they have rules for everything. Everything they've done is by rules. When I was a kid, we wanted to play football. We'd find the kid with the football, and then we'd go over to the schoolyard and we'd start up a game with a few people, and more people would see it, and they'd come gather in, and we'd choose up sides and we'd play. And we made our own rules, and we just made up our rules as we went along. We supervised ourselves. And I remember our rules were that when I was a kid, we leave the house in the morning at in the summertime when we're not in school. And the rule was we had to be back home that night when the street lights came on. And that was it. No supervision, no rules. We did everything for ourselves. But this is precisely the opposite. Precisely the opposite. This is interesting. What they say are their events. This is what they choose as their events. They think the top 10 events that influence their lives are Columbine, understandable, the war in Kosovo, the Oklahoma City bombing, the death of Princess Di, who was an icon to this group, the Clinton impeachment, the O.J. Simpson trial, which was thrown in their face on television for a whole year, the Rodney King riots, the Lewinsky scandal, the fall of the Berlin Wall, and the McGuire-Sosa home run race, which I thought was kind of funny. But that's what they regard as the 10 top events on survey, the 10 top events of their life. They're self-identifiers. This is how they describe themselves. Positive attitudes, cooperative team players, which is obviously true, accepting of authority, which is true, rule followers, which is obviously true, the most supervised, which is obviously true. Again, this is self-identification. They say they're smarter. And to a large extent, they're basing this on the fact that, I don't know, maybe the fact that they have to teach their grandfather how to use a computer. They have to teach their father how to use an iPhone. Maybe they are. I mean, they're certainly smarter technologically. They're more progressive. This millennial thing bodes well for democratic politics and for progressive politics because they are progressive. And these folks, to a very large extent, between their votes, but also their get-out-the-vote efforts and their individual campaigning, these folks, to a very large extent, put President Obama in the White House. They regard themselves as cutting edge. And they are on technology. They teach us technology. They're better educated, 50% going to college, and they're global. They don't have the local perspective. They don't have the statewide perspective. They don't have the national perspective. They have a global perspective on life because of, obviously, the World Wide Web. Now, they're nearly polar opposites of the boomers, who are their parents. They're nearly polar opposites of the Xers, who are their siblings. And they're not, this is important for us, these folks are not as susceptible to tort reform as the Xers. For one thing, obviously they're smarter. But they're just not, they won't buy this bill of goods. They're more progressive. But also, today, these people are getting more and more educated, and more people are filling the graduate programs and the law schools, and more of their people it's their goal to get a law degree, or their friend's goal to get a law degree, and they know a lot of very good friends of theirs who are in law school, and they're finding out we're not such bad folks after all. The 12 key negative events in their lives. These are the cohorts that happen to this group, the millennials. 9/11, the dot-com failures influenced them, which gave them something of a bad attitude about business. Corporate corruption, which they've had thrown in their face their entire lives, literally. A divided country, which is getting worse by the day. The untrustworthy politicians, which is getting worse by the day. The Iraqi-Afghan wars, which they largely opposed, and that's just where they get their progressive views and their Democrat views, because the Democrats opposed, to a large extent, the Iraqi-Afghan wars. Their big event is their own lack of security. They don't feel secure because of things like the Oklahoma City bombing and all these things, and 9/11 that can happen to you at any time, any place, any way. They have shrinking salaries, which is a negative event, and then they see it as shrinking opportunities because so many jobs are being shipped overseas, the outsourcing of jobs being the next negative factor, and the insourcing of foreign workers. A lot of the foreign workers who are coming in are taking the jobs that they feel they should have. You have a lot of people coming in from countries like India who are taking a lot of the computer jobs at which they feel like they're particularly qualified. So insourcing of foreign workers, there are a huge number of foreign workers being insourced into the healthcare industry. And particularly since malpractice cases have been largely outlawed in a lot of states, you now have insources of foreign workers who will work in the healthcare industry much more cheaply than the American healthcare workers. And downsizing, being replaced by the computers that they love so much. So those are the key negative elements, events that they think have influenced their lives. So in terms of generic communication across the board to all these folks, it's like a newspaper article. They always taught us in journalism, you teach, in your lead paragraph, you answer these questions: who, what, when, where, why, and how. And that's how we should prime our information in our stories. In our storytelling, you want to get their attention while they have a short attention span. If you don't grab these folks quickly, you won't grab them at all. So you take the story, the grabber in your story is who, what, when, where, why, and how, the 5 W's and how. Then you have to sequence your story. And this is very important. This applies across the board. This is not just your Gen Xers now, or Gen Y. Sequencing your story is very important. How do you put you can take exactly the same elements and you put them in different order, and they have much more impact in one way than the other. For example, the priest asked the bishop, he says, question for you, is it okay if I smoke while I pray? And the bishop said, of course not. That would be highly sacrilegious. To smoke while you pray, that's ridiculous. So then he goes and asks the cardinal, sir, is it okay if I pray while I smoke? And the cardinal says, of course, you can pray anytime. Your prayers are always welcomed by God. Exactly the same question, sequenced in a different way with different result and a different impression created by it. But we have to sequence our evidence. And sequencing with today is that we can't come in and talk about big injuries, talk about how devastated the plaintiff is, talk about physical pain, mental anguish, physical disability, and all that sort of thing, until they know why they care. They'll be sitting there thinking, subconsciously, if not consciously, they're thinking, okay, so yeah, he's injured, but so why do I care? Why? So what? So what you have to do is you have to begin by making them care, making them understand that this was caused, that there was this all started with action by the defendant, liability action by the defendant. That's why we're here today, because this defendant did this, which caused injury. Now, they'll already know about the injury from Vord iron opening, but now you have to sequence your story, and in sequencing, you have to make a conscious mind appeal, which means that you can't use just words. When you start your case, in your first part of your sequencing of your story, you have to tell things about liability that you can immediately back up, very shortly back up with hard evidence, back up with things that they can touch and see and smell and feel, back up with photographs, back up with diagrams, back up with demonstratives, back up with hard evidence, not just your words. but hard evidence that appeals and has to be processed in the conscious mind. And because we have a very short leash. If we stand up and start talking hyperbolically about injuries, or even talking hyperbolically about this evil corporation that damaged this person, without backing it up soon, without backing it up with hard evidence soon, then that word greedy trial lawyer is going to pop right into the minds of the Gen Xers, and nothing will be in the minds of the millennials, because they're all thinking about something else. So you have to engage them early. And the way you engage them is with a conscious mind appeal. And a conscious mind appeal is hard evidence. So be prepared, sequence your story so that you're making your points, and then you're following it up immediately with hard evidence to support it. Then it's only after you have them understanding that this defendant rendered damage to this plaintiff, then you can go into what that damage is all about. So the conscious mind appeal, you keep your emotional appeal. That's not to say that there's not a proper place for an emotional appeal, but you must keep your emotional appeal in their proper place and their proper perspective. You have to sequence your damage proof after your liability proof. So, and it's the Zeigarnik effect. Let me tell you about the Zeigarnik effect. The Zeigarnik effect is applied to your damage proof. The Zeigarnik effect is this, that people will hold on to those and believe and hold on tenaciously to that which they discover for themselves, much more than they will hold on to what you tell them. So what you want to do with damage proof is sequence it and present it in such a way that you let the jury discover for themselves the nature and extent of the injury of this plaintiff. For example, you have a permanent irreversible brain injury case. Okay, I think personally you're wasting it if you stand up on voir dire examination and say this is a permanent irreversible brain injury case. Or if you stand up on opening statement and say this is a permanent irreversible brain injury case, because that may be received as hyperbole at that point because you got nothing to support it. You start out with this as a head injury. And then as you go through and get more evidence into it, then it becomes a severe head injury. Then as you get further into it, it becomes a severe brain injury, then a severe brain injury, then a permanent brain injury. And then only after the doctor describes it as such does it become an inoperable permanent brain damage. After the doctor says that, because you want the sequence in the minds of the jurors to be, oh, this party's injured. Oh, this party's really injured. Wow, this is a devastating injury. Now, this is an injury that he's going to have to live with for the rest of his life. But you want them to discover that on their own. And when their mindset is that they discover that on their own, they'll hold on to that tenaciously, infinitely more than if you stand up on voir dire and say, this is a case involving permanent, irreversible, inoperable brain damage. Yeah, so what else is new? Lawyer talk, okay? The very important issue is, I've already mentioned it to you, but the question becomes, what are you doing for yourself? This is what the jurors are thinking because they're self-reliant. So what are you doing for yourself? The answer is you have to have your own plan of rehabilitation. It doesn't matter how badly you're injured. You have to have a plan for rehabilitation. Now here's the important point. If you have a case in which your party's injured and took you 2.5 years to get to in front of a jury on this. And in that 2.5 years, all their injuries have cleared up and they've recovered. Don't come in and claim permanent mental anguish, permanent that they still worry about that every day of their lives and they're going to worry about it for every day for the rest of their lives. That's the hyperbole that they reject, and rightfully so. Try the case you have, not the case you wish you had. If you've got a case that cleared up after 18 months, that's your case. And you tell the jury quite honestly, the good news in this case is, and you've heard the discussion of all these injuries, but the good news is this plaintiff worked so hard at rehabilitation that he managed to bring himself back to the point that he no longer suffers from any of these incapacitating injuries that were inflicted upon him by this defendant. His courage, his rehabilitation, his efforts brought him back, but he's back. So what we're talking about here in terms of evidence and proof is simply what he had for that first 18 months. And that's your case. You always have to be able to answer the question, what good purpose will be achieved by an award of damages in this case? What's this money going to be used for? And you have to be able to answer that question, and don't think about the answer to that question the night before you do closing argument. Start thinking about the answer to that question early in the game, because it's been our experience in certainly with focus groups and in debriefing juries that somebody is going to ask that question or something very similar to it in the jury room. So what good's it going to do if we give him $1 million? It's not going to make him walk again. It's not going to bring the father back. It's not going to do this. It's not going to do that. That's a standard question that can cause a lot of trouble. You need to have the answer to that question. You need to deliver the answer to that question, raise the question, and then answer it yourself as part of your closing argument. Explain how the money will make a difference in the life of the plaintiff. You do that on proving the rehabilitation expert, the proof of the spouse, the proof of others, as well as, to some extent, the proof through the plaintiff, depending on your individual facts. But you have to show that they can make a damages proof that will show lifetime necessity, and that this money is needed to change what's going to happen over the course of the entire life. But if you don't have a life care plan, then what will these damages make in the short term? What will they do to compensate for what's been done so far? And if you've got a compensatory case where you're just getting them to award money for what's happened so far, fine, then argue it that way. But don't try to stretch it out beyond what it really is. And don't ever use the term victim. Avoid the use of the term victim, and don't treat your client like a victim. And one of the dangers in putting a client on the stand and having them talk about their injuries and so forth is that, first of all, it can be perceived as whining if it's not done properly. But secondly, you don't want them to appear to have a sense of entitlement. I once put a young 17-year-old kid on the stand who was injured, and I just sat there and watched it while it happened, even though we'd prepared him. We watched him, and he got this sense of entitlement, that he was entitled to this. He was injured as a result of the negligence of the other party. Now, he's entitled to this money. No, you can't do that. You can't do that. It'll bite you. The theme is this plaintiff is doing the best they can with what they have left. They have to show also not that they've been doing the best they can, but that they are motivated to continue to rehabilitate on their own. avoid compensating the victim. And the reason you never use the word victim is because the majority of men in a poll thought that the victim was the person being sued. Prove, and this is a very important point, prove that the plaintiff is both in need and worthy of the help of the jury. It used to be that we could just come in and prove that they were hurt, they were injured, and they were in need. We can't do that anymore. We can't stop there. Now we have to prove that they were hurt, they're injured, and now they're in need of help, but also that they're worthy of their help. And the way you show they're worthy of their help is to show that they're doing everything they can for themselves, and on their own they can't recover. On their own they can't get to where they need to be. And that so they need the help of the jury to get them there. I've already mentioned that personal responsibility is generically the universal theme, and that applies across all of your juries, and I think in all of your cases. Now that we've discussed the characteristics of Generation X and Generation Y, let's talk about how we can communicate with this generation, particularly the Millennials, who have difficulty communicating with each other except by text. So I want to show you something now, which is a test that's been around for a long time, and it has to do with how to communicate with the unconscious mind. Now, in this test, the idea is for you to count the number of times that the people wearing white pass the basketball. How many times do the people wearing white pass the basketball? Okay, how many passes did you count? The correct answer is 15 passes, but did you see the gorilla? Now watch it again. See this? All right, most people will miss the gorilla. And it's looking at it now that you know there's a gorilla there, it's hard to miss it. In fact, you'd have trouble trying to black it out at this point. But the fact is that you have to be able to take the focus away from the unconscious mind and put it onto the conscious mind. This is all about the difference between a conscious and an unconscious mind appeal. So this is about the conscious versus the unconscious mind. The conscious mind appeal is hard evidence. It's the court's charge, for example. That's very hard for them. That's very hard evidence. That's something that they will have in the jury room with them. You want to wrap yourself in the court's charge. You want to use your language of the court's charge when framing your questions to your jurors, to your expert witnesses. You want to be talking in terms of the exact language that your damages will be in. I've heard it said that you don't want to talk about pain and suffering in mental anguish. You want to talk precisely about physical pain, mental anguish, physical disability, physical disfigurement. And you want them to understand that these are the elements of damage that they're going to be called upon to place a dollar value on. And so in the opening statement, you explain to them what their role is. They have to place a dollar value on these elements of damage. And then as you're going through your trial, as you come to evidence about that, for example, you're going to ask a treating nurse who was in the hospital room with the patient a question about pain and suffering. Well, you predicate that question with what I call a signpost. You say, all right, now let's turn to the issue of the physical pain suffered by Mr. Jones. And then you ask the question. That's a signpost telling them that, okay, now we're going to hear that evidence that we talked about on physical pain. So you wrap yourself in the court's charge, the language of the court's charge. Visual evidence is both. It's conscious and conscious mind appeal. Support by numbers. You want hard numbers to support your position on as many things as you possibly can, because those are conscious mind appeal. That's things that the conscious mind has to calculate. The focused effort to communicate with millennials is to focus them on a conscious mind appeal. What you saw and the relevance of the gorilla that you just saw is, in watching that in the normal course of things, if you just watch the video without the task of counting the number of times that the people wearing white passed the ball, you would have easily seen the gorilla. It would have been very obvious, because it would have been gathered by the unconscious mind, which just records everything. But when we gave you the task of counting the ball, counting the passes, that is a conscious mind process. So by giving you a conscious mind task, we overrode, if you will, your unconscious mind, which is why you saw the number of times the ball was passed, but you did not see the gorilla. So one of the ways that we have to communicate with people who have an unconscious mind that is thinking about everything in the world except this lawsuit is to keep them focused. And that's certainly the millennials, and to a very large extent, Gen X also. So the unconscious mind appeal is basically the communication that you want to make in the present tense. When you tell your story, there's a reason why you tell your story in the present tense. Teddy Koskoff taught me early, showed me how he sat in front of a jury. He pulled up a chair. He was talking about the death of a family, a father, a husband, and the prominent family member. And so he pulled up a chair and he said, he's not here to speak for himself, so I want to speak for you in his stead. So he spoke to the jury in the present tense, in the first person, as the deceased plaintiff. And it is powerful stuff, but it's powerful because telling things in the present tense resonates in the unconscious mind. The past tense and the future tense do not resonate in the unconscious mind. The unconscious mind gathers everything that's happening right now. Visual images, and the more color the better. The more vivid colors the better. It resonate, and they're observed and they're stored in the unconscious mind. For example, if that gorilla had been wearing a red furry outfit as opposed to a black one, just blending in with the black and white, you wouldn't have overridden it by the conscious mind. And here's a very important factor. Don't talk about negatives. Don't say the doctor failed to do this, the driver failed to do that. Avoid negatives, because negatives do not record in the unconscious mind. When you yell at that child across the room, do not drop that glass. The next thing you hear is the crash of glass, because the not does not register in the unconscious mind. More importantly, when we say that the doctor failed to do this, the failure part, he did not do this, the failure part doesn't really resonate in the unconscious mind. It has to be calculated by the conscious mind. You want to communicate in the unconscious mind, which is where your fundamental decision making takes place, and then it's ratified in the conscious mind. So the way you would say that is this. You avoid the negatives. You say, the doctor chose to do the following. In a medical negligence case, you could say, the doctor was confronted with this set of symptoms. And confronted with that body of symptoms, he could have chosen to do A, he could have chosen B, he could have chosen D, C, or he could have chosen D. If he had chosen A or B or C, we wouldn't be here today, because this tragedy would not have occurred. Instead, he chose D, which was to send the patient home without being treated. And that's why we're here today with a wrongful death case. It's the choice to do something wrong, not that he failed to do anything. And it's same thing applies. The driver chose to break the law, to break the rules of the road, by traveling 70 in a 55-mile zone. Those rules are there for a reason. They're to protect the other members of the public on that highway. He chose to break that rule, and you see the consequences. That type of argument. That is an unconscious mind appeal. Rhetorical devices. These are your metaphors and your analogies and the rule of three. Metaphors are powerful, powerful tools. When you give a metaphor about any situation, the metaphor is calculated. It goes directly and communicates directly in the unconscious mind. It's not something that the conscious mind has to stop and do. Analogies, the same thing. Powerful analogies. I give a whole speech just on rhetorical devices and how to use rhetorical devices. Analogies are the same way. Powerful analogies will resonate directly in the unconscious mind where the decision making takes place. There's no question that we put things together in threes. When you talk about three separate things, how important it is to couch things in terms of threes. Ask Governor Perry about that. It's just a simple fact that our mind is devised in such a way that we remember things in threes. So do things in threes. Of the people, by the people, for the people. The rhetorical question is extremely powerful. And so, ladies and gentlemen, who is going to correct the grave injustice that has been visited upon this plaintiff by the negligent conduct of this defendant? If not you, who? And if not now, when? That's a powerful rhetorical question. I've used it many times. Seek similarities, because similarities resonate in the unconscious mind. We like people who are like ourselves. We find ourselves, you go to a gathering and networking and you meet somebody and you like them and you're describing them later and say, you know, we had a lot in common. I like this guy. We had a lot in common. We were a lot alike. We seek similarities because we like people who are like ourselves. So we seek jurors who will be similar to and have the same likes and dislikes and understandings as our plaintiff, as our expert witness, as us. Just be careful about having someone too similar because of defensive attribution. Anchoring is another topic that you really need to learn a lot about. I mentioned it about having an anchor so that when the judge calls your name, the jury expects something to happen. You do that by making something happen when the judge calls your name. Nonverbal communication, vocal communication, and neurolinguistic programming. Nonverbal communication, the reason it's 55% of the persuasive process is because it occurs in the unconscious mind where decision making takes place. Vocal, same thing, 37% of the persuasive process because it occurs in the unconscious mind. Neurolinguistic programming is all about communicating with the unconscious mind. I would want to learn as much as I could possibly learn about that, and I have. It's powerful stuff. Focusing on the demographics and the generational differences, the way to do this is to conduct focus groups. So you say, okay, fine. This is great, Howard, if I'm going to try a case to nothing but millennials, or if I'm going to try a case to nothing but Gen X, but I get them all. Well, of course we do. We all do. So what you're trying to do here, first of all, is you want to find out what is going to resonate from your case with the millennials. How are the millennials going to talk about your case? What language are they going to use? What metaphors are they going to use? How are the Gen Xers going to do the same thing? How are the boomers going to do the same thing? So the way you do that is you conduct focus groups with nothing but millennials. What we do just to make sure you get the same input is we'll have a group, for example, of 21 focus group members or 24 focus group members. And we'll have 8 boomers, we'll have 8 Gen Xers, and 8 millennials. And we will make the presentation to them as a very blank, that is non-adversarial presentation, so that we want to hear them talk about the facts of the case. We're not interested in them deciding who's the best lawyer. We're interested in them see how they process the case. So you make a very plain vanilla presentation to them of all the facts, of everything you want them to know about the case. Then you divide them up into 3 groups and put the millennials together, the Gen Xers together, and the boomers together. Then the first thing you do, you listen to how they talk. You record it all, video it all. You listen to the language of the case. You listen to the language that they use to describe your case. Every case has its own language. Every case has its own terms. And you'll find that the Gen Xers may talk about the same event in your case with different language than the boomers do. So you're going to want to have to incorporate everybody. You're going to want to get it all in there so that it resonates with everybody. But mainly, here's a very powerful tool. When they're talking about it, you ask them at the end of their discussion, usually I go back and say, okay, answer this question for me. X is just like, and take whatever your issue is. I had an issue involving defibrillation. So I said, okay, defibrillation is just like, now everybody write down your answer to this question. Now, and what they do is they'll give you a metaphor then that describes it. Well, I came up with a great metaphor. I got this one from my doctor, but defibrillation is just like electrocution, that type thing. They take a medical term or a technical term or some language of your case that may be complex, and they simplify it and they put it into their language. But their language may be different from the language of the boomers. So you want to get everybody's language. So you put them in different groups, let them talk about it, and then you want to test your technology in front of all of them. So you do the same thing. You show them all the same graphics, the same demonstratives, whatever you're going to use, and then test them on their response to it. Show and tell demonstratives, same thing. Storytelling across demographic lines. The way you get to storytelling is you then ask them, you give them the vanilla presentation, but then you can go back and you can do a second presentation, a second focus group, in which you, instead of giving a plain vanilla presentation, you tell your story. You tell the plaintiff's story the way you would to a jury in opening statement. Then you divide them up into the 3 groups. And then you listen to how they discuss your story. And the first thing you do is you give them a questionnaire based upon it. Every time you put them separated, you give them a questionnaire to answer specifically, individually, whatever questions they have, whatever question you have of them, so that before they start being influenced by general discussion by everybody else, you get their individual opinions. Then you tell a story. Then you put them into separate groups. And then you listen to how they talk about their story, how they talk about your story. Then whoever's debriefing that group in the millennials will say, okay, how would you like to have heard this differently? Who else would you like to have heard from? Who has another important part of this story that might have been told? How else could this be told? What's missing from the story? What's the best part of the story? What's the weakest part of the story? And let them discuss the story for you in detail. Do the same thing with the boomers, and somebody else is in another room doing the same thing with Gen X, and see what you come up with. You end up with a story that you can take all the parts and build a story that resonates across demographic lines with the proper story. So you do the vanilla presentations, you do distinct groups, and then you do mixed groups, and you split them up. You submit written questionnaires to them, you videotape all your proceedings, and I use 18, 21, or 24, depending on the individual case, depending on the issue that I'm trying. And we may do 15 focus groups in one case. I once tried it. I had a case that was getting ready for trial against General Motors. Before I ever filed suit, I had a multi-death case. Three people burned to death, and I had 2 people burned severely. And before I ever filed suit in that case, I did a total of 56 focus groups. Now that's the kind of case that would justify that. So I did 56 focus groups. I tested every single part of that case before focus groups, so that before I filed suit, when I filed that petition, I could have walked upstairs in the same courthouse and picked a jury. I was completely ready before I ever filed suit. And I got ready through focus groups. And by the time I got to where I was starting discovery, I already knew what I needed. I knew what my story was. I knew what my themes were. I knew everything I needed to be proving. And so I had a big, huge leg up on that case. So your method of recognizing the differences is watching the videotapes, having one person watch the videotapes. You got a person in the room in each room with them, but then you have to sit down and you have to watch all 3 videotapes and compare differences. Then you also get to compare differences on the written answers. That's why the written answers are so important. You listen then and develop the language of your case that you're going to use in trial that is such that it carries all of the language, that it communicates your story to everybody, regardless of their age, regardless of the group that they're in. Then you develop your metaphors and make sure that you have metaphors. You may find that one metaphor is so powerful it resonated with everybody. If not, then you may have to have a different metaphor for Gen X and Gen Y and yet another one for the boomers. And that's okay. Use 2, 3, use whatever number of metaphors you need. But metaphors are powerful because they communicate directly with the unconscious mind. The next thing, you do a rule of 3 quiz at the end of the presentation. I always ask them, list the 3 most important things that you saw in this that you think influenced your decision making. They don't really, keeping in mind that they don't really know why they decided the way they decided, but you want to know what they think are the 3 most important things that influence their decision in the case. And then the second thing is, what are the 3 greatest strengths of the plaintiff's case? And then in that same one, what are the 3 greatest weaknesses of the plaintiff's case? Then what are the 3 greatest strengths of the defense case, and what are the 3 greatest weaknesses of the defense case? Then we go through, separately I talk to them in terms of rhetorical devices. I talk to them in terms of analogies, and that's when we get together and say, finish this sentence. This is just like what? This is, what analogy would you use? Or we have analogies that we've thought up. There's 2 ways to do this. One is you take the metaphors that you've come up with in your own workup and try them out on them and see what works best. But the other more important one is to have them tell you their metaphors. You want to do that first. Before they hear yours, you have them tell you what their metaphors are. That's where you'll get different metaphors that resonate directly with the millennials and with the boomers and with Gen X. So you test your graphics. I've never done a graphic since I did my first focus group in 1984. I've never, ever done a graphic, a piece of demonstrative evidence, or a timeline without presenting it to a focus group. Every time I think that we've got a graphic already and boy, it can't get any better, and we've tested it out with lawyers, referring attorneys, paralegals, everybody, we think, boy, we got this one nailed, and we go in and present it to a focus group, they always find a way to improve it. Timelines, extremely important. Jurors questioned say that timelines are the most helpful, timelines properly done are the most helpful single graphic that you can use. I give a whole 1-hour speech just on timelines. But quickly, the biggest mistake on timelines is trying to put too much information on the timeline. Every single item on a timeline should have a very definite meaning, a meaning that the juror understands when they look at it. Timelines can be, we have digital timelines that may run for 10 feet if you put them on a wall, on paper, but when you can pull them up digitally, it's very easy. Then you want to test the rules. What is their reaction to the rules that you're relying on, and how do they think you could better present the rules and the effect of the violation of the rules, and just what do they think of the rules? Protocols, the same thing with malpractice cases. What do they think of the protocol? Do they understand the protocol? Do they understand the reason for the protocol? And how would they present the protocol? How would they improve your presentation of the protocol? So you test cross-generational storytelling, then you put together a story that reaches everybody based on what you've learned, and you test your case-specific facts. Now you take your case-specific facts, you put it all together into this, and after you do all that, then you bring in a focus group that consists of everybody all mixed up together, and you put it all, you test it with them all at one time, just like you would a jury, and let them deliberate together and see how the whole thing works when you don't separate them, because that's the way the jury will be. Test the response to each element of damage. And in psychology, the things that we learn are the reptile, the culture code, the rules of the road. Those are all things that I think are extremely important right now for us to study and know, and then we test the rules with the juries, and we see what works. I hope this has been helpful to you in helping your clients. Thank you very much.